I have heard angry litigants threaten attorneys, witnesses, landlords, business owners, and even entire corporations. But only once did I watch someone stand in my courtroom, point directly toward the bench, and threaten to sue the judge presiding over her own case. What happened afterward remains one of the most unforgettable moments of my judicial career. The woman believed her threat would intimidate the court. Instead, a single response changed the entire direction of the trial and left her completely speechless. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. My name is Judge Judith Harper. Over the years, I learned that people reveal their character most clearly when they stop getting the outcome they expected. This case involved a homeowners association dispute. At first, it appeared routine. The plaintiff was a woman named Karen Sullivan, 51 years old, sharp, confident, extremely outspoken. She lived in an upscale suburban neighborhood governed by the Maple Ridge Homeowners Association. The defendant was HOA Board President Christopher Hayes, a former accountant. Soft-spoken, methodical, not the type of person who sought confrontation. Karen had filed a lawsuit alleging that the HOA had unfairly fined her, selectively enforced neighborhood rules, and targeted her because she frequently challenged board decisions. Those allegations immediately caught my attention. HOA disputes often become deeply personal. People stop arguing about rules and begin arguing about respect. And when that happens, facts can become difficult to separate from emotions. The courtroom was packed that morning. Several neighborhood residents had come to observe. That alone was unusual. Most civil disputes attract little public interest. This one attracted plenty. As Karen entered the courtroom, I noticed something immediately. She behaved as though she were addressing an audience rather than participating in a legal proceeding. She smiled toward spectators, waved to several people, even nodded dramatically whenever her attorney mentioned the HOA. Years on the bench teach you to notice these things. People focused on justice usually focus on evidence. People focused on attention often focus on reactions. Christopher Hayes sat quietly at the defense table. He avoided eye contact with Karen. He reviewed documents carefully. His demeanor suggested concern rather than hostility. That distinction mattered. Then testimony began. Karen spoke passionately. According to her account, the HOA had repeatedly fined her for minor landscaping violations while ignoring similar violations committed by other residents. She described receiving warning notices, penalty letters, threats of additional enforcement. At first, her testimony sounded compelling. The jury listened carefully, so did I, but something felt incomplete. Not wrong, incomplete. Because every time she described a conflict, she portrayed herself as entirely reasonable and everyone else as entirely unreasonable. Human behavior rarely works that way. Reality tends to be messier. Then Christopher Hayes took the stand. And that was when I noticed the first crack in Karen's story. He brought records, photographs, inspection reports, meeting minutes, dime correspondence. Years of experience have taught me that organized evidence often tells a more reliable story than emotional testimony. Karen seemed unbothered. In fact, she appeared unusually confident, almost amused. And then something happened that changed everything. Christopher's attorney displayed an email exchange between Karen and the HOA board, a long exchange, dozens of messages. As portions were read aloud, the atmosphere in the courtroom shifted. Because the emails revealed a side of Karen the jury had not yet seen, demanding aggressive, confrontational. And when one particular message appeared on the evidence screen, I saw Karen's expression change for the first time. The email ended with a sentence that made several jurors look up immediately, a sentence that hinted she had made a threat long before she ever entered my courtroom. At that moment, I knew this case was about to become something very different. What I did not yet realize was that before the day ended, Karen would make an even bigger threat, a threat directed at me. And when she did, the response she received would leave the entire courtroom frozen in silence. The second day of trial began with a very different atmosphere than the first. The confidence Karen Sullivan displayed when she entered the courtroom had not disappeared, but it had changed. There was tension beneath it now. The kind of tension people carry when events are no longer unfolding according to plan. I noticed it immediately. Judges spend years studying testimony, evidence, and procedure. But perhaps the most valuable skill we develop is observation. People reveal far more through behavior than they realize. As proceedings resumed, Christopher Hayes remained calm. He reviewed documents, spoke quietly with counsel, answered questions directly. Karen, meanwhile, appeared increasingly focused on the audience seated behind her. Every reaction seemed important to her, every glance, every whisper, every expression. That concerned me, because courtrooms are not stages. At least they are not supposed to be. The defense continued introducing emails exchanged between Karen and the HOA board over a 2-year period. The volume alone surprised the jury. More than 80 separate messages, dozens of complaints, repeated disputes, arguments over landscaping standards, parking restrictions, holiday decorations, mailbox colors, fence height regulations, small issues individually, but together they revealed a pattern. And patterns matter. One email stood out. Christopher's attorney displayed it on the screen for everyone to see. The message had been sent by Karen late one evening following an HOA board meeting. The language was striking, not because it contained profanity. It did not. Not because it contained threats of violence. It did not. What made it remarkable was its tone, calculated, controlled. Intimidating. Karen wrote that if the HOA continued enforcing rules against her, she would make life extremely expensive for everyone involved. I watched the jury carefully. Several members immediately began taking notes. Karen crossed her arms. That reaction told me she recognized the significance of the message. Years on the bench teach you that genuine misunderstandings rarely generate dozens of escalating confrontations. Something deeper was happening here. Then another email appeared. This one addressed directly to Christopher Hayes. The message accused him of harassment, corruption, abuse of authority. None of those accusations had ever been formally substantiated. Yet Karen repeated them frequently. That observation struck me. Because experienced judges learn to distinguish between evidence and accusation. One is proof. The other is merely assertion. The defense attorney then asked Christopher a simple question. Did the HOA ever single out Miss Sullivan for enforcement? Christopher answered calmly. No. Did the HOA issue similar notices to other residents? Yes. Do you have records? I do. The records were immediately introduced. And that was when the atmosphere changed again. Photographs, violation notices, compliance letters, dozens of examples involving other homeowners. The evidence suggested that enforcement had been far more consistent than Karen claimed. I noticed jurors exchanging glances, not dramatic glances, thoughtful ones, the kind people make when a story begins shifting beneath their feet. Karen became visibly irritated. She interrupted repeatedly, objected unnecessarily, argued with witnesses. Each interruption required additional warnings from the court. Then came a moment I still remember vividly. Christopher's attorney displayed another email. This one was sent only 3 months before the lawsuit. The message ended with a sentence that immediately captured my attention. If this continues, I will sue every person involved, including anyone who enables this behavior. At first glance, it seemed like ordinary legal posturing. People threaten lawsuits all the time. But something about the wording lingered in my mind, especially the phrase anyone who enables this behavior. At the time, I wasn't sure why it stood out later. I would understand exactly why. Because that sentence revealed a pattern. Karen viewed disagreement as hostility, rules as persecution, and authority as an obstacle to overcome. What none of us realized was that this mindset would soon lead her into a catastrophic mistake. A mistake made in open court, a mistake witnessed by every juror, a mistake that would culminate in her threatening not just the HOA, not just the attorneys, but the judge himself. And when that moment finally arrived, the entire courtroom would witness a response she never saw coming. By the 3rd day of trial, the dispute had evolved far beyond landscaping violations and HOA fines. The real issue was becoming increasingly clear: credibility. Every case eventually reaches that point. The facts matter, the documents matter, the law matters. But sooner or later, the court must determine whose version of events is supported by evidence and whose version depends primarily on persuasion. Karen Sullivan had spent days portraying herself as the victim of an overreaching HOA. Yet the documentary evidence was beginning to tell a more complicated story. That morning, the defense introduced meeting recordings. Official HOA board recordings, lawfully maintained, properly archived, carefully documented. The jury listened through portions of several meetings. Christopher Hayes appeared in those recordings exactly as he had appeared in court, measured. Patient. Professional Karen appeared differently, much differently. Again and again, the recordings captured confrontational exchanges, interruptions, personal accusations, repeated demands. At one point, she accused the entire board of conspiring against her because they declined a proposal regarding parking regulations. When the recording ended, the courtroom remained quiet. I watched the jurors. The shift was becoming noticeable, not dramatic. Gradual, but unmistakable. They were no longer simply listening to Karen's claims. They were comparing those claims against evidence. That is where truth often emerges, not from a single revelation, but from repeated contradictions. Then Christopher's attorney introduced HOA correspondence from multiple residents. Several homeowners had submitted statements regarding interactions with Karen. The statements were not identical. In fact, they differed considerably. Yet they contained recurring themes: arguments, threats, demons, escalating disputes. Bartal's human behavior leaves patterns, and patterns are difficult to ignore. Karen objected repeatedly. I overruled objections that lacked legal basis. Each ruling seemed to frustrate her more. I noticed something changing in her demeanor. Her confidence had begun transforming into resentment. That transition is important. People who believe they are winning tend to remain composed. People who feel control slipping away often do not. Then came a particularly revealing exchange. Christopher's attorney displayed a letter Karen had sent to the HOA several months before filing suit. The language was forceful. Near the end of the letter appeared a sentence that immediately captured everyone's attention. "You will regret underestimating me." The attorney asked Christopher whether the board interpreted the statement as a threat. Christopher answered carefully. "We viewed it as intimidation." The jury wrote notes. Karen rolled her eyes dramatically. That reaction did not help her. Years on the bench have taught me that jurors pay close attention to behavior, especially behavior that occurs when evidence becomes uncomfortable. Then something happened that I found deeply revealing. Karen requested permission to address the court directly. I granted limited permission. She stood, straightened her jacket, looked toward the jury, then toward me. What followed sounded less like testimony and more like a speech. She argued that everyone was biased: the HOA, the witnesses, the attorneys, the process itself. According to Karen, every unfavorable piece of evidence resulted from unfair treatment. Every contradiction was someone else's fault. Every problem had an external explanation. As she spoke, I found myself reflecting on something years of judicial service had taught me. One of the strongest indicators of credibility is the ability to accept responsibility for even small mistakes. Karen accepted responsibility for nothing. Not one decision, not one action, not one escalation. And that observation stayed with me, because when people believe every problem originates elsewhere, they sometimes begin viewing authority itself as the enemy. I did not yet know how significant that realization would become, but before the day ended, Karen's frustration would reach a breaking point, a point where she would stop attacking evidence, stop attacking witnesses, and start attacking the court itself. What she said next would stun everyone present, and it would set the stage for the most unforgettable confrontation of the entire trial. The fourth day of trial began with a feeling I had experienced only a handful of times throughout my career. The case was approaching a breaking point. Not legally, but psychologically. There is a difference. Legally, the evidence was continuing to develop in an orderly fashion. Psychologically, however, the pressure inside the courtroom was building rapidly. And pressure changes people. It exposes character. It reveals priorities. It strips away carefully crafted appearances. Karen Sullivan entered that morning looking determined. But determination can take two forms: the determination to prove your case, or the determination to avoid losing. By this stage, I suspected the second was becoming more dominant. The defense continued presenting records. Nothing dramatic, nothing theatrical, just documentation, HOA notices, meeting minutes, photographs, correspondence. The kind of evidence juries often trust because it exists independently of emotion. Karen grew increasingly impatient. Every unfavorable document seemed to trigger another objection, another complaint, another accusation. At one point, she openly suggested that the HOA board had fabricated years of records. The allegation was serious. But when asked for evidence supporting it, she offered none. That moment mattered. In court, accusations require proof. Without proof, they remain accusations. Nothing more. Then Christopher Hayes took the stand again. This time, the questioning focused on Karen's interactions with the board after receiving violation notices. Several emails appeared on the screen. The jury reviewed them carefully. Most were argumentative, some were hostile. A few crossed into outright intimidation. One message stood out in particular. Christopher was asked to read it aloud. His voice remained calm. I have resources you cannot imagine. If this continues, every person involved will wish they had handled things differently. The courtroom grew quiet, not because the statement was illegal, because it revealed a mindset. A belief that pressure could solve problems that facts could not. I watched Karen carefully. She appeared angry that the email had been introduced, not surprised, not confused. Angry that distinction mattered. People react differently when confronted with evidence they know exists. Then came the exchange that changed everything. The defense attorney asked Christopher whether HOA enforcement actions had continued after Karen threatened legal action. Yes. Why? Christopher answered immediately, because the rules applied to everyone. Simple, direct, powerful. The jury appeared impressed. Karen did not. She stood abruptly, without permission, again. Her voice echoed through the courtroom. This entire proceeding is ridiculous. I instructed her to sit down. She remained standing. The tension in the room became palpable. Jurors watched silently. Spectators leaned forward. Court staff stopped moving. Years on the bench have taught me that some moments require patience. Reacting emotionally only makes matters worse. So I waited. Karen pointed toward the defense table, then toward me. And suddenly the focus of her frustration shifted, not toward Christopher, not toward the HOA, toward the court itself. She accused the process of unfairness. She accused the defense of manipulation. Then she made a statement that immediately captured everyone's attention. If this continues, I'll take legal action against everyone involved. The room fell silent. I had heard similar threats before. But something in her tone suggested she was not finished. She was escalating. The question was how far she intended to go. As I looked at her standing in the center of the courtroom, visibly frustrated and losing control of the narrative she had tried so carefully to build, I realized we were approaching a moment of no return, because within minutes, Karen would make a threat so extraordinary that several jurors would later describe it as the most shocking moment of the trial. She would look directly at the bench, directly at me, and announce her intention to sue the judge. What happened immediately afterward would leave her completely speechless. The final day of the trial felt very different from the first. When Karen Sullivan originally entered the courtroom, she appeared convinced that confidence alone would carry the day. By the end, the focus had shifted entirely, not to personalities, not to threats, to evidence. That is where every courtroom should eventually arrive. The jury listened carefully to the closing arguments. Christopher Hayes' attorney kept his presentation straightforward. He reviewed the documents, the emails, the meeting records, the violation notices, the photographs. Most importantly, he focused on consistency. The HOA had enforced the same rules against multiple residents. The records supported that conclusion. The witnesses supported that conclusion. The documentation supported that conclusion. Karen delivered her own closing argument afterward. She was passionate, determined, at times emotional. She argued that the HOA had treated her unfairly. She argued that the board disliked her. She argued that the entire dispute stemmed from retaliation. Some jurors listened attentively. Others reviewed their notes. But something had changed. The emotional force of her arguments no longer carried the same weight. Because jurors had spent days comparing those arguments against evidence. And evidence leaves impressions that are difficult to erase. Then deliberations began. Those hours always feel longer than they actually are. No matter how many years a judge serves, waiting for a jury's decision never becomes routine. Eventually, the courtroom was notified that a verdict had been reached. Everyone returned to their seats. Karen sat rigidly. Christopher appeared nervous. The gallery filled quickly. The atmosphere was tense. The foreperson stood. The verdict form was handed to the clerk. I still remember the silence. No whispers, no movement, only anticipation. Then the verdict was read. The jury found in favor of Christopher Hayes and the Maple Ridge Homeowners Association. Karen's claims were rejected. The jurors concluded that the evidence did not support allegations of selective enforcement or improper conduct by the HOA. As the verdict was announced, I watched both parties carefully. Christopher lowered his head. The relief was obvious. Months of accusations, months of legal expenses, months of uncertainty. Finally ending, Karen remained completely still. No outburst, no protest, no dramatic declaration. Just silence. Sometimes silence arrives when every argument has already been exhausted. After the jury was dismissed, I offered a few final remarks before formally closing the case. I spoke not only to the parties before me, but to a lesson that extended beyond this dispute. I explained that disagreement with authority is not wrongdoing. Questioning decisions is not wrongdoing. Seeking legal remedies is not wrongdoing. Those rights are fundamental. But rights come with responsibilities. Evidence matters. Facts matter. And no amount of pressure can substitute for proof. Then I addressed something I knew everyone in the courtroom was still thinking about: the threat. Karen's threat to sue the judge. I explained calmly that courts cannot function if decisions are influenced by fear of criticism, fear of accusations, or fear of litigation. Justice depends upon independence. Without that principle, fairness becomes impossible. The courtroom gradually emptied. Jurors departed. Attorneys gathered their files. Court staff completed their final tasks. Soon, only a handful of people remained. As I sat alone reviewing the final paperwork, I found myself reflecting on the moment that had become the defining memory of the case. Not the verdict, not the arguments, not even the threat itself. The response. Documents don't get intimidated. The reason that statement mattered was simple. Truth does not become weaker because someone becomes louder. Facts do not change because someone becomes angry. Evidence does not retreat because someone issues threats. Those principles are the foundation of justice. Over the years, I have seen powerful people attempt pressure. I have seen emotional people attempt persuasion. I have seen angry people attempt intimidation. But the outcome is always the same when a court remains focused on facts. Eventually, evidence speaks for itself. And when evidence speaks clearly enough, no threat is powerful enough to silence it. That is why this case stayed with me long after the courthouse doors closed, because it reminded everyone present, including me, that the loudest voice in a courtroom should never be a person. It should always be the truth.